Merci beaucoup. Je veux dire que je suis ravi d'être encore une fois à Paris, où j'ai étudié une vingtaine d'années, et je suis très reconnaissant aussi envers Laurence et Conan et Fadine pour l'invitation pour participer dans cette journée d'études. Malheureusement, je n'ai pas le courage très admirable de mon compatriote Tala qui a parlé aussi couramment pendant 10 minutes. Moi, je suis beaucoup plus timide, donc je vais continuer en anglais. Je suis désolé. Alors, in the UK law, which first of all comprises 3 different legal jurisdictions, as I'm sure you know, England and Wales, Scotland and Northern Ireland, the law can, generally speaking, be categorized in this fashion as regards diffamation. Diffamation doesn't, I think, translate very easily into English. It's tempting to define it as, or to translate it as defamation, but I think it connotes something more than that, at least from what I've heard about French law and German law. I'm going to be spending most of my time, 90% of my time, on the first part of that slide. So defamation in civil law, suing people for libel, which is the permanent form, recorded form of defamation, or for slander, which is the spoken or impermanent form of defamation. I'll then say a few words about the tort of malicious falsehood, which has similarities to the tort of defamation. I'll say very little indeed about criminal law, because English law in general, British law in general, has a lot of legislation in the area. There is comparatively little case law, and I understood the focus of today's Journée to be on the contribution of judges to the development of the law on defamation, or to the interpretation of that law. And there isn't much to say about, ironically enough, what the judges in the common law systems in the UK have done to develop the criminal law in this sphere. So I'm going to focus mostly on libel and slander. And I'm going to give you a list of cases, just the names of cases to which I'll be referring, so that if you're interested, you can follow them up in your own time. So, for there to be defamation, there has to be damage to a person's reputation. The purpose of the civil law in this sphere is to protect the reputation of people, whereas the purpose of the criminal law, such as it is I think, to keep people safe in the community, to protect them against violence, or potential violence. And as I think Tarek said earlier today, in the UK, it's possible for businesses to sue for defamation, just as individuals can sue, because businesses have reputations. And he gave the example of the McLibel 2 case, which is an excellent one to provide. A large corporation suing and winning for defamation against 2 ordinary individuals. It's not possible, however, to bring a defamation action in relation to someone who has died, or to a business which is no longer in operation. A lot of the law in this area has recently been not quite codified, it's not as extensive as that, but it has been put into legislation. In 2013, a Defamation Act was passed by Parliament, which clarifies the law to an extent and replaces some of the common law principles and defences with statutory defences. But a lot of the precedents which pre-existed the 2013 Act will still be relevant to future interpretations of the 2013 Act. Just about the most important change made by the 2013 Act was that for anybody to successfully sue for defamation, they have to prove not just harm to their reputation, but serious harm to their reputation. And a business, if it wants to sue, has to prove not just financial loss, but serious financial loss. And as you might expect, unfortunately, the Act does not define what serious harm or serious financial loss means. So straight away there's a decision there for judges to make in these cases. But the fact remains that the harm must take the form of the lowering of somebody's reputation in the eyes of right-thinking people. Again, that was mentioned earlier. Or, as one court put it, it's where you're suing for having been exposed to, having exposed a person to hatred, contempt, or ridicule. In Scotland, where they like to use different words for the same thing, because they're very proud of their separate legal system, they say that defamation would be words or expressions which are derogatory, disparaging, demeaning, or calumnious in the eyes of the reasonable person. So you get the picture. It's attacking somebody's honour or dignity. Those words are never expressly used, as far as I know, in the case law. But that is the underlying purpose, I think, of the protection of reputation. And it takes many forms. So in a leading case, the Liberace case involving the famous American pianist, he sued somebody, the newspaper, for the allegation that he was gay. This is back in the 1950s. They didn't say he was gay. They said, quote, he was a scent-impregnated, luminous, quivering, giggling, fruit-flavoured, mincing, ice-covered heap of mother love. Which I think is quite complimentary, actually. But he didn't at the time, although, of course, later he came out as gay. But he won damages for that litany of insults. And in Berkhoff and Burchell, this is where a well-known British journalist, Julie Burchell, she described an actor, Stephen Berkhoff, whom you might have heard of, as quote-unquote hideous looking. Now, normally, of course, she went on to compare him with Frankenstein's monster. Normally, that would not be defamatory because it's purely insulting. It's offensive, but no worse. But the court said that because he was an actor, this insult, and this degree of insult, actually did lower his reputation in the eyes of right-thinking people. Presumably, right-thinking people believe that all actors must be, good-looking. Not logical, but that was the contextual approach adopted in that case. And in the Town Parky case, a Muslim leader who was well known for being very liberal in his views, such as regards the role of women in Islam, he successfully sued a magazine called the Muslim Weekly for claiming that his views meant that he was not a proper Muslim. I've already cited the McDonald's case where they successfully obtained £40,000 of damages, which was a fraction of the legal expenses that were required in that case, which went on for more than 10 years altogether, if you include the European Court handling of the case. That corporation won because Mr. Steele and Miss Morris were alleging untrue things about the products of McDonald's. or the ingredients of the products of McDonald's. And that was deemed to cause serious financial, well, sorry, that wasn't the criterion then, but financial loss to the company. The Act that I mentioned, the 2013 Act, takes away the presumption that defamation cases in the UK should be dealt with by a jury, where a jury decides the facts, the judge gives guidance on what the law is that should be applied to those facts, and the jury then decides whether there has been defamation or not. And, unusually, they can decide what damages should be awarded. Now, the Act says that the presumption should be that there is no jury in the case, which, if you like, enhances the role of judges in defamation actions. But in the 5 years that have elapsed since the Act was brought into effect, there isn't yet really enough case law to say what the judges are thinking about the meaning of serious harm or serious financial loss, which are now the criteria to be applied. And very often what the judges do is they hold a preliminary hearing called a meaning hearing to determine the meaning of what was allegedly said and whether it constitutes harm at all, let alone serious harm. So in Cook and MGM, where the chief executive of a housing association sued for defamation because she was written about in a way that suggested that she was a slum landlord, that her housing association was treating its tenants very badly, exploiting them. Now, the newspaper, as soon as it discovered this allegation, deleted from its website what it had said in the article and published an apology in print. And by the time the meaning hearing came up in the action, it was much more easy to access the apology online than it was to access the original alleged defamation. Although the court held that the allegation of defamation was, on the face of it, plausible, actually, even at this preliminary stage, they said it could not amount to serious harm, and therefore the case ended at that point. Now, just a few years later, in a case that I've neglected to put on the list there, it's called La Show against Independent Print. This is in 2017. The court changed its view in Cook. This was a case where a man was accused of falsely kidnapping from his wife their son, and he was also falsely accused of beating his wife. In that case, during the meaning hearing, the Court of Appeal said that whether these allegations were true or not, on the face of it, they were likely to cause serious harm. And so the case could proceed. It was not struck out at the preliminary stage. And in the Brett Wilson case, the court said it is possible to infer, in this case, serious financial loss, even though there was no evidence, no hard evidence to prove it. This is a relic of the common law principles that in defamation you do not have to prove damage. It's actionable per se. So in this case, where somebody alleged that a firm of solicitors were, quote, solicitors from hell, it was held that that of itself would inevitably lead to a serious financial loss, because clients would not go to the company, to the firm of solicitors, for advice, and clients who were currently with the company might leave them, and there was actually some evidence that the latter had happened. But the main point of that decision is that the court itself can infer serious financial loss. There are other common law rules which the judges maintain. For example, that in a defamation action, the expression used can only be deemed to have one meaning. That once the court has determined what that meaning is, that's the one it has to run with, even if there are other potential meanings. And it's also possible, through judicial discretion, to extend the limitation period that people have in which to bring defamation actions. So the normal statutory limit is 1 year, although in Scotland it's 3 years. But there is a discretion on the part of the court to extend that. And in this Bury and Reed Elsevier case, where a foster parent was accused of inappropriate conduct in relation to a foster child, that particular man was allowed an extra 16 months, so more than 100% of the original time was granted to him to bring an action, because it took him some time to negotiate with the defendant as to whether they would settle the case out of court or not. So the judges seem quite generous in extending the time limit period. Now, as regards defences to defamation, obviously truth is a defence. It used to be called justification in English law, but the statute now calls it truth. There used to be a defence of fair comment. It's now the defence of honest opinion. The most important development that there has been on that defence occurred in the Reynolds case in 1999. This was a case where the former Prime Minister of Ireland, Albert Reynolds, sued the Times newspaper for alleging that he had misled the Irish Parliament. And the paper argued that it had a defence, namely qualified privilege. It cited New York Times and Sullivan, saying this man's a celebrity, he's a prominent politician, he can take the criticism. They also alleged, or they tried to allege, that this was a political matter and there should be a privilege given to political speech. But on the facts of the case, the House of Lords, the highest court at that time in the UK, said no. There was defamation here because the journalists had not taken enough care to check their facts before writing the article. So the subtext was that if in a future case the journalist did, as it were, do his or her best, but still made a mistake, that would be okay. That would not be defamation. If you like, that was an obiter dictum in the case. And true enough, a few years later, in Jamil and the Wall Street Journal, Europe, where a Mr. Jamil, a Saudi businessman, was complaining that the newspapers were alleging that his bank accounts were being monitored. He sued for that, and he lost on that occasion because simply the court said, this was still the House of Lords, said that the journalist in question had behaved as a reasonable journalist would behave, checking the facts. So Mr. Jamil, he wasn't an elected person, he was a prominent businessman, but he wasn't a celebrity as such. He was an ordinary individual. But still, he was unable to successfully sue a newspaper or a journal, a magazine, for an untrue statement about him. So, while the UK has not bought into the New York Times and Sullivan case law 100%, it has nevertheless moved, I think, quite generously towards favouring newspapers, giving them the benefit of the doubt, if you like, in situations where, despite all the care that they have taken, they have made a mistake. There is also a statutory defence, which I won't go into, for operators of websites. There's a special set of regulations, the defamation bracket operators of websites regulations 2013, which allow a kind of defence to an operator of a website if they immediately react to a complaint. They try and contact the person who put the post up onto the website in the first place, and if they don't hear back from that source and then take down the posts themselves, the operators, then they have defence basically. And there's an added offence, I'm glad to say, for academics in the statute. Following a very controversial case in Britain where somebody was successfully sued for a mistake they made in reviewing a scientific paper, it's now a statutory defence to fairly comment on something in a review, if it's a scientific paper, scientific in the broadest sense. You have a defence if you're being, in the judge's eyes, fair and accurate. And lastly, it's not quite a defence, but it certainly goes to mitigation of damages if the defendant has apologised prior to the case coming to court, has offered to put in a statement reversing the earlier statement, or offering compensation to the other side. An area that has been quite difficult for the courts is that relating to the costs in defamation cases. They can be very extensive. In the Flood and the Times newspapers, three groups of newspapers complained that they were being ordered to pay not just the ordinary costs of the successful claimant, but also the so-called success fee of their lawyers. So the lawyers had promised, had demanded a higher fee if they were successful in the case. And the claimant had also taken out what was called after-the-event insurance, whereby after you've discovered that you can sue, you take out insurance against losing your case, and you pay a high premium for that. But in this case, the newspaper said we shouldn't have to pay back all those extra costs to the claimant. But the Supreme Court, as the House of Lords had become by then, held that no, they did have to repay all those sums of money. And that was despite a decision by the European Court of Human Rights, which followed on from the Steele and Morris case, and also on a case involving the Naomi Campbell, the model who had successfully sued in Britain for damages. There, the European Court had said that British law breached Article 10 because it imposed such a heavy liability for costs on defendants in defamation cases. But wrongly, I think, but nevertheless, the Supreme Court in Britain said they were not strictly bound by that European Court decision, and they weren't, on particular facts of the Flood and Times newspaper case, going to state a general rule of the common law whereby excessive damages would be a violation of any right of the defendant. I'm conscious of time, so I just mentioned the last case there, Tully and Fry. That illustrates, I think, the distinction between suing for defamation and suing for malicious falsehood. That was the tort I mentioned earlier, malicious falsehood. To sue for it, you have to show that the defendant maliciously published a false statement and that it caused the claimant financial loss. So it's very similar to defamation, it just requires malice. The plaintiff in Tully and Fry could have relied upon that because his image was used by this chocolate company, Fry and Sons, to advertise their chocolate products. He was an amateur golfer, and he had never given his consent for the use of his image. And it damaged his reputation and his financial circumstances. But he chose to sue successfully, as it happens in defamation, rather than in malicious falsehood. So it's not frequently used, that tort. Moving on finally to criminal law. As I indicated on the first slide, there are basically these three categories of crimes that can apply here. So there's a statutory offence under the Malicious Communications Act and the Communications Act of 2003. They cover articles which are indecent, grossly offensive, or threatening. So if an individual complains of that kind of message, then the prosecution service can take action. We don't in the UK have, as I know you in France have, the partie civile system, where a third party who has been injured by a crime can intervene in the criminal case. That doesn't happen in the UK. There is a power in the court to order compensation to victims, but it is actually very rarely exercised, unfortunately. In the Connolly case, an anti-abortion campaigner sent very lurid images of aborted fetuses to chemists, to pharmacists, who were selling the morning after pill. And they said that they felt threatened by these messages. They were upset by them, they would cause distress and anxiety. The Director of Public Prosecutions decided to prosecute, and Miss Connolly, who had sent the images, although she said she had no intent, malicious intent, she was held guilty of sending these offensive communications. And as regards communications that might have been put online, perhaps outside the jurisdiction, the court in Shepherd decided that if an offender had produced, in this case it was a racially inflammatory document, if they had posted it on a website, on a remote server, say in the United States, which happened in this case, the trial could still take place in England and Wales, so long as the person affected by that statement was carrying on most of his activities in England and Wales. If the centre of his activities was there, then a criminal action could be based in the UK, in England and Wales in that case. There's also hate speech legislation criminalising, in particular, the stirring up of hatred based on race or religion, not actually on grounds of gender or politics or even disability. But in those situations, the court is at liberty to increase the sentence given to the defendant. So it's not a separate offence, but it does affect the sentence. And there's also the crime of harassment. It's actually a civil wrong as well, harassment. It necessitates a course of conduct, and in this Flavel case in 2014, the judge held that the repeating of malicious assertions against a doctor who was being investigated by the professional body for doctors constituted a course of harassment. Whether what was being said was true or not, it was a course of harassment. And the Court of Appeal upheld the conviction of Mr. Flavel in that case. Other crimes to do with defamation, so the crime of sedition, of obscene libel, of blasphemy, of defamatory libel, all those old offences have been cleared away from the statute, but they no longer exist in any part of the UK's law. So summing up, I think we can say that, if I can use the phrase English law here, it does protect people's reputation and their integrity in a variety of ways, but it's mainly through victim-led civil actions rather than through state-led criminal actions. A free speech, I think, is pretty well protected in the UK. Of course, we can talk about marginal cases. I mean, it's rare for judges to limit free speech on the basis that the speech involved is is offensive. It has to be a lot more than offensive to incur any kind of legal sanction. Thank you very much.